When I sentence someone to listen to the words coming out of my mouth, stop talking for a minute. When I sentence people on a misdemeanor to jail time, that isn't like a felony where it would stack. Do you understand that? Okay, this carries a maximum penalty of up to a year in jail. I don't know how long you've been in jail, but, you know, and then once you're sentenced, I think then you're available to Mr. Face or whatever MDOC is gonna do. And, but listen to me, because I want to make sure you understand that sentencing would be about 6 weeks out. You understand that? Say yes.
Yes, ma'am.
Okay, so,
Please get closer to the mic.
kind of move the microphone so it's between you guys and yell it, okay? Miss Adams, can I get that file back, please?
Yes, sure.
Mr. Sneed, thank you. This is date and time set for a pretrial and Isaac Sneed appearing on behalf of the people. So, Miss Beecher, how would you like to proceed?
Good morning, Your Honor. Christine Beecher on behalf of the defendant, Chad LaFountain. Your Honor, Mr. LaFountain wishes to proceed this matter to trial. So if we could just get a scheduling order in place.
You gotta speak up.
Could we discuss this for trial, Your Honor?
All right. I apologize, the mics in here are not that great and the audio sometimes is not good. All right, so, Mr. LaFountain is charged with 1 count of failure to comply with registration or reporting duties. This is the 3rd offense, so it actually carries a maximum penalty of up to 10 years in prison if he's convicted at trial. So, I'm 1 day. I can't imagine it'd be more than 1 day trial.
I think 1 day would work. I know there's about 3 different agents involved.
Mr. Stain, 1 day.
Yeah, sure.
Okay, I think. So, Miss Adams, I'm looking for like a Tuesday or a Thursday, starting at 9. I know he's in custody. But he was arraigned for prelim in February, March, April, May, June, July. So we're at 180 days. You want to bring me the book? You can give me the book. We could probably stack up another trial.
I'll be right.
Just like, here's this darn book. Just pick it out. It's not in jail, it's 40. Two. All right. All right, so the problem is we're running into like a several week jury trial. This is jury, you said?
Yep.
Not bench.
I'm in no hurry, Your Honor. Yeah, I've been on a case for 10 months already, so I mean, if we gotta take time, we can take time.
No.
I'm on dead time anyway, so I'm on parole, so.
Okay,
But I have a question though, why we're.
ask her.
I did ask her, it's concerned my bond.
Yep, well, we're gonna trust him.
He's on a parole holder.
He thought he was eligible for MDOC at some point.
Yeah. The way I understand is, yeah, I'm arrested on parole hold. I'm available for the DLC to come get me. My 45 days has been up already. So if my 45 days is up, I'd like to request charge to bond. I'd still be on parole.
Becky, did NPI versus the Addison development, did that one settle? It didn't?
I don't think so. What's that file?
Say it again.
I don't think so, but what's that file number? I'll check.
23-7032CH. Okay, so I can do October 14th at 10 a.m. I have David Welke set that day with Mr. Banetto and Mr. Murphy, but I don't believe he's in custody.
I'm scheduled to be in trial in judicial Sabres on that day, Your Honor.
Okay, whatever. So I could set this for Thursday, November 12th, starting at 9 a.m.
That works for me,
Is that
Judge.
good?
Thanks.
All right, I will set a final pretrial for Wednesday, November 4 at 8:30 in the morning. I will make that the motion deadline. And I will require that jury instructions and voir dire questions be submitted to the court by October 30th. Miss Adams, could I get a copy of this for Mr. LaFountain?
Yes.
All right, so we will get a copy of that for your client here. While we're waiting. All right, is there anything else we need to address on the record?
Your Honor, only if he was eligible for bond, if we can address bond, or is he on a parole hold until this case is resolved?
So he's on a holder right now?
When I was arrested, I was told by Agent Face, that I was arrested on the violation, but I was arrested on child support case at the same time. He told me when he came to see me that I would, my time would be run concurrent with my violation or with my child support time. My violation time would be, which is already up. That was back in October 12th. I was done with that. So I had 45 days from the day that I'm arrested. So if my 45 days is already up, I've already been offered a PR bond on this twice.
I don't.
I've tried to contact Face myself through mail. I've tried to contact the parole supervisor through mail. I've not got a response back from either one.
Miss Rogers, can you ask across the hall what's going on with him?
Yes, Judge, let me go ask Agent Pace.
Yep. Hold on a second.
Thank you.
Good morning.
Mr. Face. We have Mr. LaFountain here and he's asking me questions about parole that I really can't answer. What is his current status? Has he served all his time on his parole violation?
He's currently what we call a number 2 warrant because he has a bond because he's not available to the Department of Corrections right now.
I was available. You told me I was available the day I got arrested.
You got to speak louder into the microphone.
I was available.
But we're not going to fight
Don't look away.
here.
You said when I got arrested for the child support that my time ran concurrent with my time for my child support. So that would be my 45 days are already be up.
Mr. LaFountain currently has a bond, so he's a number 2 warrant, so we have a parole hold.
I'm trying to get my bond lowered so I can bond out.
If I were to reduce his bond, and I'm not saying I am, to a PR today, would he be released from the Lenawee County Jail?
He would not. We would have to submit our parole violation. It would go from us to our supervisor to the parole violation unit.
So you want to stay where you're at right now? Okay. All right. Thank you, Mr. Face. All
Yes,
right.
ma'am.
So we have provided a scheduling order to Mr. LaFountain, so he has that. And I'll leave the bond where it is. And we will see you back for pre-trial on that.
Thank you.
If it gets resolved is there a plea offer in this case, Mr. Sneed?
There is.
What's the plea offer?
The plea offer was to an attempted failure to court. It was like a high court misdemeanor.
Well, the underlying charge is a 2-year. So would an attempted be the 1 year?
No, his
Is that just?
charge
Hold on.
currently is the, failure to comply with the Registration Act, the 10-year, third or subsequent
I think-
offense.
Yeah,
It's a 10-year. So the offer was a misdemeanor, high court misdemeanor of 2 years, which is it's called failure to report, just so.
right. I understand that. So the max penalty be 2 years, Mr. Sneed?
Well, I think we were willing to do an attempt of the failure to report, which would make it a 1 year down from the 2, since we'd
So
be
if I sentence him
dismissing.
on that, it's a county jail term and it doesn't stack. So if you want to talk to him today and if he
Okay.
wants to plead to that misdemeanor,
The attempt of the SORA. Okay,
Yeah, I mean, I'll.
talk to her quietly.
Okay. Yeah, she's saying that.
When I sentence someone to listen to the words coming out of my mouth, stop talking for a minute. When I sentence people on a misdemeanor to jail time, that isn't like a felony where it would stack. Do you understand that? Okay, this carries a maximum penalty of up to 1 year in jail. I don't know how long you've been in jail, but, you know, and then once you're sentenced, I think then you're available to Mr. Face or whatever MDOC is gonna do.
Let's do that.
But listen to me, because I want to make sure you understand that sentencing would be about 6 weeks out. You understand that? Say yes.
Yes, ma'am.
Okay, so,
Sir, please get closer to the mic.
Yes, ma'am.
kind of move the microphone so it's between you guys and yell it, okay? Miss Adams, can I get that file back, please?
Yes, sure.
Mr. Sneed, thank you. All right, here we go. Here, you want these? All right, so, Mr. LaFountain, so we've had a conversation here today. Raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes.
Okay. And you're kind of soft-spoken, so make sure you're speaking up good. Now, you've heard the discussion. So the plea offer that's been made in this case is plead to an attempted failure to comply with reporting duties, which would be a 1 year misdemeanor. Do you understand that?
Yes, ma'am.
So it carries a maximum penalty of up to a year in jail.
Yes, ma'am.
All right, and Ms. Beecher has gone through all this. She's met with you and talked to you. Are you satisfied with her as your attorney and the advice that she's given you?
Yes, ma'am.
And neither the prosecutor, the defendant, or anyone on the defendant's behalf has discussed any possible sentence with the court, other than it would be a jail term. Is that correct, Ms. Beecher?
Correct, Your Honor.
And Mr. Sneed?
That's correct.
I swore him in, right?
Yes.
I got all discombobulated. All right. So, if a guilty plea is accepted, you understand that trial we just set won't happen. Do you understand that?
Yes, ma'am.
This means that you'll be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. And my bailiff is actually going to walk down to you a copy of your advice of rights to kind of look at real quick and sign, and then I'll continue.
Yes, ma'am. I understand.
Kind of look at them for me and sign them.
Richard. No, I just, right now. So unless I'm released to the courthouse, so.
What? I'm sorry.
He was asking for the address and I said, unless I'm released to the courthouse.
Okay. All right, so now I have a signed copy of the advice rights and I'm gonna read through them with you. So do you understand if as I said, if a guilty plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have a right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask your witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial and not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that?
Yes, ma'am.
Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
Yes, ma'am.
Do you understand that if plea is accepted and you engage in any misconduct as defined in MCR 6.310 between now and sentencing, the court will not be bound by any sentencing agreement or evaluation, and you will not have a right to withdraw your plea. Misconduct is defined to include, but is not limited to, absconding, failing to appear for sentencing, violating terms of conditions on bond, or the terms of any sentencing or plea agreement, or otherwise failing to comply with an order of the court pending sentence. If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you understand all of that?
Yes, ma'am.
And do you have any questions about any of the rights that I've given to you?
No, ma'am.
Now, you're already required to register as a sex offender, and you understand you will have to continue to do so.
Yes, ma'am.
All right, so Mr. LaFountain, how do you plead to the charge that on or about September 15 of 2025 in the city of Adrian in the county of Lenawee, that you did commit the offense that will be added as count 2 in an amended information to attempted failure to comply with reporting duties? Guilty or not guilty?
Guilty.
All right. Has anyone made any threats or promises to you to induce you to plead guilty to this charge?
No, ma'am.
Do you understand if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea? Do you understand that?
Yes, ma'am.
Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty? Ms. Beecher?
No, Your Honor.
Mr. Sneed?
Your Honor, I just wanted to clarify the statute for the record that we're offering. It's a attempt failure to report. It's under MCL 28.729 subsection 2. The original penalty is a 2-year high court misdemeanor, but with the attempt, that does drop it down to a 1 year. So I just want to specify and place that on the record. That will be the added count 2.
Okay, thank you. Any objection then, Ms. Beecher?
No, Your Honor.
All right, excellent. All right, so is it your own choice to plead guilty?
Yes, ma'am.
All right, so, Mr. LaFountain, you are required to register under the Michigan Sex Offender Registration Act. Is that correct?
Yes, ma'am.
And how often are you supposed to do that?
Twice a year.
All right, and then you're also required to notify them if you change your address. Is that
Yes, ma'am.
correct? And now on September 15 of 2025, were you on that day required to change or verify your address?
Yes, ma'am.
And did you fail to do that?
Yes, ma'am.
Okay. Mr. Sneed, or are you
No,
satisfied
people
with
are
that?
satisfied.
All right, has the court complied with the MCR 6.302 B, C, and D? Ms. Beecher
Yes, Your Honor.
and Mr. Sneed?
Yes, thank you.
All right, I accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. This court has made no agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them. My next question will be, and I have no position on this, based on the nature of the offense, Mr. Sneed, and Ms. Beecher, typically on a misdemeanor probation, we wouldn't put them on probation, it would be a jail term. Mr. Sneed, are the people requesting a pre-sentence report from district court?
Your Honor, I defer to Agent Face. I'd like to have his input regarding the PSI and setting sentencing out. Thank you.
Your Honor, can I ask a probation agent what they would recommend?
The
As far
district
as-
court?
Yes,
Yeah, we need a PSI.
Okay, So, all right, I will set this for sentencing on. First thing I had to do. All right, I'm gonna set this for sentencing on October 2nd at 8:15 in the morning. So October 2nd at 8:15 in the morning. Mr. LaFountain, do you want to be here in person
Yes,
or
ma'am.
in person?
Yes, ma'am.
All right, so Mr. LaFountain, probably, I don't know who it'll be, someone from district court is gonna come over and meet with you at the jail. They'll ask you about your background, the events that occurred, just be truthful with them. They'll prepare a report, and then we'll get a copy to Miss Beecher, and she will review that with you before sentencing, okay? All right, anything else we need to address? All right, bonds
No, thank you.
continued. Thank you.
Thank you.
Hi, this is Judge Anzalone. So it looks like you guys had a busy day and I have a ton of pickups. So I am ready for Jasmine Sarabia, Cody Gage, and Bobby Della Garza.
Alrighty.
And then I have, I'm waiting on a different attorney for Mr. Lambert. So I'm ready on
No.
all of them. Wait, hold on. What, Ms. Underwood?
I think you're confused, Your Honor. I think you're waiting for another attorney on Mr. De La Garza.
Oh, all right. So Randall Lambert, Cody Gage, and Jasmine Sarabia.
Lambert, Gage, Sarah.
Yep. Thank you.
Alrighty. Yep.
Bye.
Bye.
Sorry to interrupt you.
No, you're not. Thanks for the correction. Rhonda keeps me in line. Well, I'm gonna hang up and Miss Adams, if you can get the jail on the second floor, I'm ready for Jake Klein. I don't have Miss Beecher yet, so, all right, Miss Underwood, I'm gonna arraign Miss Edmonds, she is here. So.
Great.
Miss Edmonds, if you can start your video and your audio, please.
Can you, wait,
Oh, Miss Edmonds, can you hear me?
yep, I can hear you.
All right, excellent. This is file number 2024-1983FH in the matter of the people of the state of Michigan versus Christina Mia Edmonds. This is the date and time scheduled for request and summons for probation violation. So, Ms. Edmonds, it is alleged that you have committed several technical violations of your probation. One is that they allege you failed to report as instructed in the month of July. The second one is that you failed to enter residential treatment as instructed on or about June 22nd of 2026. The third is that you have not attended outpatient treatment as instructed since on or about June 23rd of 2026. And the last one is that you failed to submit to drug testing as instructed for the month of July. So those are the allegations against you for a technical violation of probation. You are currently on possession or on probation for a controlled substance possession less than 25 grams. So if you were to plead guilty or be found guilty, you could be facing up to 4 years in prison. Now, Ms. Edmonds, you do have a right to have an attorney represent you on this and all subsequent hearings. If you can't afford to hire one, we have an attorney you can speak with today. So would you like a court-appointed attorney?
Yeah,
Your Honor,
Okay.
I believe she already has me.
I do.
I don't know, but okay. Do you need a breakout room with her?
Really, Your Honor, I don't. I'm in possession of a letter from this Lindsay Bucking or from Olivia Jackson at the Salvation Army, Your Honor, giving an update on Ms. Edmonds' treatment. I believe the probation department also may have that. So I would just like to enter a not guilty plea on Ms. Edmonds' behalf, Your Honor, and see where we end up with this.
Is she an inpatient program?
She completed a residential treatment program, and she remained through August 6th, where she successfully transitioned. I have the letter. It's right. I can bring it into you, Your Honor.
Okay. And did that go to the probation department, Ms. Walsh?
We have it, Judge. We have the letter.
Okay, so Ms. Underwood, what I will do is I will set this out. I'll enter a plea of not guilty and I'll set this out to, and Ms. Rogers, I know this isn't your file, but do you have any objection to me setting this out to like September 16?
No, Judge, that's fine.
And in the
Right,
meantime,
so-
Ms. Edmonds, report to Ms. Walsh.
Okay.
Right, so Ms. Edmonds, I'm gonna set this out to September 16 at 8:30 in the morning. Continue to report to Ms. Walsh, test, and do everything you're supposed to be doing, okay?
All right. Thank you.
All right, thank you, Ms. Edmonds.
Yeah.
All right, Erica Benson, if you could unmute your device, please.
All right.
Ms. Benson, can I ask what case you're here for?
The right,
Oh, hold on, Ms. Benson, hold on a minute. Hi, this is Judge Anselone again. I am ready for Israel Vila as well.
Okay, sounds good.
All right, thank you, bye.
Bye-bye.
All right, I'm sorry, Ms. Benson. Can I ask what case you're here for?
I believe it's the right. Erica Wright.
Yep, okay, so that is the date and time set for a pretrial. You're just here to watch the proceedings?
She's on the docket.
Oh, your name's Erica Wright.
Your Honor, that's her.
Yes.
Okay, well, her screen says Erica Benson. That's why I was asking. Okay. All right, I'm sorry. All right, here we go. So this is file number 2026-22678 FH in the matter of the people of the state of Michigan versus Erica Lynn Wright. Ms. Underwood, I'm assuming that means you represent her, correct?
I do, Your Honor.
All right, so this is the date and time set for a pretrial conference. I do have a letter from Darren Coast dated August 10 of 2026, stating that Ms. Wright has not been testing due to medical reasons. I'm not going to go into that. We do have verification from U of M and Chelsea Hospital. That going forward, we can just have her come to court hearings in person and test her when she's here, just to alleviate those other issues that we have. So Ms. Underwood, how would you like to proceed with Ms. Wright?
Your Honor, I talked to Mr. Coast yesterday afternoon, and we agreed, and I hope the prosecution will agree, that perhaps to put this out for a month or two until Ms. Wright feels a little better. She's had some medical issues, would be appropriate.
Mr. Bandetto, are you the prosecutor?
And I'm happy to do the stip to adjourn.
Okay, Mr. Amadeo, is this your file?
I'm sorry, Judge. Is this Stella Garza?
No, Mr.
Okay.
Bandetto, I'm sorry, Mr. Bandetto, is this your file?
It is, Your Honor, yes.
All right, did you receive the email from Mr. Coast? I don't think we typically send it to the prosecutor.
I did not, no.
All right, Mr. Coast, would it be possible to get a copy of your letter to Mr. Amadeo or Mr. Bandetto so he's aware of what's going on?
Absolutely, Judge.
All All right, so Ms. Wright, I'm gonna adjourn this out to September 16 at 8:30 in the morning. I'm gonna ask that you come in person, so just to save you from having to do the testing like we normally require, I'm gonna have you come in person and you can just test while you're here, okay?
Yes.
Okay, and we will see you back on September 16th at 8:30 in the morning. And Ms. Underwood's gonna do the stipend order. Mr. Bandetto, can she sign your name with permission?
She can, thank you.
Okay. All right, excellent. Thank you. So Ms. Wright, you are all set. Just remember, going forward, come in person, okay?
Thank you.
All right, thank you. Okay. So many people. All right, Randall Lambert. Let me grab your file. Okay. All right, this is file number 2026-22513FH in the matter of the people of the state of Michigan versus Randall Allen Lambert. This is the date and time set for a violation of probation arraignment. Mr. Lambert, it is alleged that you violated the terms of your probation, and then on or about August 10 of 2026, you engaged in assaultive, abusive, threatening, or intimidating behavior toward Jennifer Ellis Berger. The second allegation is you violated the terms of your probation and that you had prohibited contact with this individual. And it's alleged you violated a term of probation that you failed to enroll in a domestic violence program. So you are currently on probation for felonious assault, which carries a maximum penalty of up to 4 years in prison. If you were to plead guilty or be found guilty, it's my understanding, Mr. Lambert, you do have some pending charges. You do have a right to have a court-appointed attorney. I know that you qualify for one. So would you like an attorney appointed to represent you?
Yes, I do.
All right, and Ms. Underwood, you have already reviewed the file and you're the one that informed me that there are some pending charges. Is that correct?
Yeah, I was just going to explain that to him, Your Honor. He does.
All right, so Mr. Lambert, because you have pending charges stemming from these allegations on the violation of probation, I'm assuming Ms. Underwood's going to ask for an adjournment on this to see what happens with those new charges. Is that correct, Ms. Underwood?
That would be correct, Your Honor.
And
Mr.
how
Lambert,
far out?
I'm happy to talk to you for a second, but that is correct.
How far out would you like an adjournment, Ms. Underwood?
I would say 2 weeks, Your Honor.
How about September 2nd? All right, so I'm going to adjourn this out to September 2nd at 8:30 in the morning. And Mr. Lambert, we'll see you back on that day. I'm assuming in the interim, you're going to be arraigned and court dates set on these new charges so that your attorneys can figure out what's going on there. And we do the notice because it's a bot. So you're all set, Mr. Lambert. Thank you.
Just for the record, Your Honor, I'm asking that the court enter a not guilty plea on Mr. Lambert's behalf.
Thank you.
Judge, can I ask what bond is set in this matter?
I believe I set his bond in the 25,000 cash. Sorry. All right, there we go. All right, you're all set, Mr. Lambert. Okay. Let's see. I have somebody in jail Zoom 3. Can I ask what your name is? On the wall behind you, it has a 3. Cody Gage. All right, let me grab the file. All right, this is file number 2024-21921FH in the matter of the people of the state of Michigan versus Cody Wayne Gage Sr. This is the date and time set for a show cause in this matter. All right, Ms. Sarabia, I really apologize. I'm gonna pop you in a waiting room for just a minute because we're getting a lot of background noise from the first floor, and I'll bring you right back. So, Mr. Gage, it is alleged that you have violated the terms of your probation, that you consumed intoxicants on or about August, or no, this is a bond condition, right? No.
Correct, Judge.
Oh, it's a bond condition. All right, so it's alleged that you violated your bond conditions and that you consumed some type of intoxicant on or about August 11 of 2026 and registered a .027 BAC on August 11 at 8:24 a.m. That you registered a .02 BAC for pretrial services coordinator Darren Coase that same morning at 8:52. And you told probation officer Tom Moore that you had consumed vodka and orange juice earlier. So those are the allegations against you, Mr. Gage. A violation of probation can carry up to 93 days in jail as a contempt of court. And it can also result in a change in your underlying bond conditions. Now, you have Mr. Daly and Mr. Mott. Is that correct, Mr. Gage?
I think I have Mrs. Underwood.
Your Honor, this is a violation of probation that was set for September 30th. And now we're here on a bond violation.
So, Ms. Underwood, how would you like to proceed? How do you want to proceed? What do you want to do?
Well, I would ask the court to, well, first I want to talk to Mr. Gage.
So, Mr. Gage, I'm going to change your screen name. And I am going to then open up a breakout room for you and Miss Underwood. And I forgot me. Sorry about that. All right. So I'm going to pop you two in a waiting room and then.
And Judge, mine is actually it's a show cause. He's actually in on a parole detainer after he registered numbers. Tom Moore elected to have him lodged.
Okay, so this is a show cause and there's nothing holding you in jail on mine. All right, so Mr. Gage, you and Miss Underwood join that breakout room.
But he's in on a parole detainer, Darren?
Correct. Yeah, but mine is just a show cause.
Okay.
All right, you go ahead and have a chat with him. Let's see, I have Mr. Klein. Your attorney's not here yet. Mr. Vila, so Mr. Goldstein, I do have Mr. Vila. And Mr. Amadeo is here on, okay. All right, so let me get Mr. Vila's file. And you're here on Simmons as well, Mr. Goldstein, but I don't have him yet. But it's not quite, well, I guess it is.
I don't see him and I don't see Zach Rosenberg either.
Not yet, but maybe. All right, this is in the matter, we have two files, 2025-22210 FH, 2025-22368 FH. In the matter of the people of the state of Michigan versus Israel Vila Jr. I have David Goldstein appearing on behalf of Mr. Vila. Miss Arnold, you are appearing on behalf of the people.
I am, thank you.
All right, this is the date and time set for pretrial. So, Mr. Goldstein, how would you like to proceed today?
Your Honor, I received yesterday dozens and dozens and dozens of pages of discovery, photos, videos. How much of it is stuff I already had, because I already had a lot, and how much of it is new, I can't tell you because I just got it yesterday. So I think we're going to unfortunately have to adjourn this a couple more weeks. Give me a chance to go over it and talk to my client about it.
Judge, I'll just place on the record, we previously sent everything to the public defender's office. We did not have an appearance from Mr. Goldstein. I'm not sure why. And when he said he did not have videos that we previously sent to the public defender's office, who should have provided him with those, I just asked my legal assistant to send him everything to make sure he had everything in the file.
Okay, well, I appreciate that, Ms. Arnold. I did have the written discovery from the public defender. I just didn't have the videos and the photos and those I did receive yesterday.
Okay. All right. So Mr. Goldstein, it depends on how much time you need. September 2nd, September 16, any Wednesday in September is available.
September 2nd would probably work, Your Honor. If the written discovery that I was sent yesterday is the same, it's just the videos and the photos I need to look at.
Okay.
Yeah, there
right.
haven't been any supplemental reports in a long time, so that should all be the same.
Okay.
So I will set both of these files over to September 2nd at 8:30 in the morning. And Mr. Goldstein, if you could do the stipend order to adjourn. Ms. Arnold, can you sign your name with permission?
You sure can.
Okay.
All right, and Mr. Goldstein, I do not have Mr. Rosenberg or Mr. Simmons yet. If you wanted to make a call, it's fine. There's no rush.
I will do that, Your Honor. Israel, I'll be in touch,
right.
okay?
All right, thank you, man.
Thank you, Mr. Vila.
Yeah.
All right, Ms. Underwood, back with Mr. Gage on file number 2024-21921FH. So evidently it's a show cause on the violation of bond conditions and he's in jail on a parole detainer and it's a pretrial. So Ms. Underwood, I think I got it all straight now. So how do you wish to proceed?
Your Honor, I'm just to get myself clear. We call it a parole detainer. He's only on probation. He's never been paroled.
That's correct. It's a probation detainer.
Okay, thank you. Your Honor, we're scheduled for September 30th. Is there any way we can move this up? That's a long time.
September 30th for a pretrial?
Yeah, we are.
Yeah, I can move the pretrial up to September 2nd, September 9, September 16.
September 2nd would be great, Your Honor.
Okay, so we will set this to September 2nd at 8:30 in the morning. I'll enter a plea of not guilty and can you do the stipend order to adjourn, Ms. Underwood?
It's a probation violation, Your Honor.
But it's a pretrial. I don't know. We'll do the notice. Okay,
Thank
we'll
you.
do the notice. Thank you, Miss Adams. Miss Adams will do the notice. All right, Mr. Gates, you're all set. Thank you. All right, so now I have Mr. Klein, Jake Klein, Mr. Amadeo. I'm just waiting for some of your people. All right, in the matter of the people, oh gosh, we have four files, 2022-20712FH, which is a probation violation and contempt. And then we have file number 2023-21223FH, which is a probation violation and a contempt court. We have file number 2023-21225FH, probation violation and contempt, and then file number 25-22402FH, which is a probation violation and contempt. Does he have some new charges too, Ms. Underwood?
Your Honor, that's what we were going to get
All right,
to.
hold on, I got a couple people talking or I'm picking up an echo, so start over again, Brenda.
Your Honor, that's what I was going to get to. Mr. Klein has a pretrial with my colleague, Mr. Raquette, tomorrow. And so I would ask that these, with Mr. Berkey's consent, and I did talk briefly to the AG's office yesterday, that this matter be adjourned for a couple weeks, giving Mr. Raquette a chance to do his work.
Yeah, so Mr. Burkett obviously has some new felony charges, which could or could not possibly result in a prison term. I don't even know what those charges are yet. Do you have any objection to us adjourning this out a couple weeks?
Your Honor, good morning. For the record, Mark Burke, P54935 at the Attorney General's office. I suppose I don't really have an objection to that. I think it's already been adjourned at least one other time.
All right, so we will adjourn this out to, I'm gonna do September 16th at 8:30 in the morning. Miss Underwood, in the event that he's coming up here sooner. If they could just let us know, we'll try to get them all together, all right?
Thank you, Your Honor.
All right, Ms. Adams will do the notice because it's a violation of probation and where all right, Mr. Klein, you're all set. Thank you. Let me
And
get
thank you very much,
in-
Ms. Underwood. Thank you.
Thank you, Mr. Burke. Have a good
Thank you,
day.
Mr. Berkey.
You too. Thank you.
Anybody in here, a defendant that has a hearing today?
What?
Are you here for court? What's your name? What's your last name? Spence? Okay, I'll get to you in just a minute. All right, Ms. Sarabia, hold on, let me grab your file. This is file number 2025-22249FH in the matter of the people of the state of Michigan versus Jasmine Elizabeth Sarabia. This is the date and time set for a show cause. Well, there was a motion affidavit and bench warrant that was done. So we have two things today. We have a contempt of court and we have a violation of probation. There was a request and summons for probation violation filed on March 16th of this year, alleging that on or about March 5 of 2026 or any time thereafter, you failed to report. At the time that was filed, it was a technical violation. But more than 90 days have, well, it's April, May, June, July, August. So it's been about 4 months. So this very well can be now considered a non-technical probation violation. You are currently on probation for possession of cocaine, less than 25 grams. So if you were to plead guilty to that violation of probation or be found guilty, you potentially could be facing up to 4 years in prison. So that show cause was mailed out. You failed to appear for that show cause on April 1 of 2026. So we issued a warrant at that time, and now that is a contempt of court, which carries a maximum penalty of up to 93 days in jail. Ms. Sarabia, you do have a right to have an attorney represent you here today in all subsequent hearings. If you can't afford to hire one, we can appoint you one at county expense. Would you like an attorney appointed to represent you?
Yes.
Okay, so I'm going to open up a breakout room and I'm going to put you and Miss Underwood in it. You will go automatically. When she's done speaking with you and she comes back, I will bring you back in, okay?
Okay.
All right, there we go. Hey, it's Judge Anzalone again. So I am ready. I'm ready for everybody.
You're ready for everybody?
Everybody.
That's a lot of people. So you need a Fountain, Ramirez, and Barnett.
Yeah, and let's see, I already did, I took care of Vila, took care of Gage. We took care of Klein, so it looks like De La Garza, Lambert, Fountain, Ramirez, Bowerman, yep.
I thought you got Lambert already.
Oh yeah, I did do Lambert, okay.
So you're like Fountain, Ramirez, and Barnett.
Okay.
Fountain's here.
Oh, the Fountain's here in person.
Oh, yeah, he went in person. Never mind. So just Ramirez and Barnett, right?
Yeah, I think so, yeah.
Okay, sounds good.
Just, I'll take them all. All right, thank
Okay,
you.
okay, bye.
Bye. So Ms. Beecher, Mr. LaFountain is in lockup. Okay. All right.
Your Honor, I'm covering Ramirez for Mr. Dagger Margosian, so if I could speak to him.
You just called for him, did you?
I just called for him,
Okay, thank you.
but I was just letting you know that one of your people is, are you down in Judge Olsaver's jury room?
Yours.
No, I'm in, I think your jury room.
Okay.
I can go in Old Savers.
No, I just meant that, what's his name is down the hall if you want to go talk to him.
Mr. LaFountain. Okay, thank you, I will.
Okay, thank you. All right, Mr. Spence, you want to come on out? Just stand at that podium right in front of the microphone. All right, this is file number 2023-21377FH in the matter of the people of the state of Michigan versus Michael Charles Spence. So Mr. Spence, we are here in a request and summons for probation violation, which alleges that you violated your probation and committed technical probation violations. So first one, it alleges that you used or possessed alcoholic beverages or intoxicants as documented in the Hillsdale Police Department Report 26-47, whatever. And then the second one is that you violated the terms of your probation by failing to make the monthly payments towards your child support arrears. You have a balance of $22,076.89. So failure to pay child support as a felony carries a maximum penalty of up to 4 years in prison. So if you were to plead guilty or be found guilty, you could be facing that penalty. Do you understand that?
Yes, ma'am.
Now, let me see here. Control order. Let me find something real quick. Okay, so would you like an attorney appointed to represent you?
Yes, ma'am.
Okay, so why don't you go have a seat in the courtroom? Miss Underwood is back, but I'm gonna finish up her people and then she'll come in and talk to you, okay? All right, thank you. So Miss Underwood, Mr. Spence did ask for court appointed counsel, so we're kind of tuck him to the back of our docket here. All right, let me bring Miss Sarabia back. She's not already back. All right, we are back on the record in file number 2025-22249FH in the matter of the people of the state of Michigan versus Jasmine Elizabeth Sarabia. So, Ms. Underwood, have you had a chance to speak with Ms. Sarabia?
I have, Your Honor.
And how would you like to proceed with Ms. Sarabia today?
Thank you, Your Honor. Well, I don't believe, according to the jail sheet and according to Ms. Sarabia, that there are any pending charges coming, Your Honor. So I believe Ms. Sarabia would like to accept responsibility today as far as the violation of probation and the contempt, Your Honor.
Okay, all right. So Ms. Sarabia, the room you are in doesn't have the greatest audio. So if I ask you to speak up, I'm not yelling at you. I just need you to speak up so we can record it, okay?
Okay.
All right. So, Ms. Sarabia, raise your right hand for me, please. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right. So, Ms. Sarabia, you would ask for court-appointed counsel. We appointed Ms. Underwood to represent you. Have you had ample time to speak with Ms. Underwood?
Yes, Your Honor.
Are you satisfied with Ms. Underwood as your attorney and the advice that she has given you?
Yes, Your Honor.
All right. Now, do you understand that you have a right to contest the violation of probation charge and the contempt of court?
Yes, Your Honor.
Do you understand that during that hearing, you would be presumed innocent until your guilt is proven by a preponderance of the evidence? Do you understand that?
Yes, Your Honor.
You have a right to have all the witnesses appear against you at your hearing, to have your lawyer ask those witnesses questions, or you could ask them yourself, and to have me order any witnesses you might have to appear at that trial. Do you understand all of that?
Yes, Your Honor.
You do not have to testify at your hearing, and no one can say anything about you not testifying or hold it against you in any way. Do you understand all of that?
Yes, Your Honor.
On the other hand, do you understand that you have a right to testify at your trial if you want to testify?
Yes, Your Honor.
Okay, so Ms. Sarabia, how do you plead to the charge that you violated the terms of your probation by failing to report on March 5 of 2026 or any time thereafter? Guilty or not guilty?
Guilty.
And how do you plead to the contempt of court that you failed to appear for a probation violation hearing on April 1 of 2026? Guilty or not guilty?
Guilty.
Do you understand that by pleading guilty, you'll be giving up your right to a hearing, as we've already explained to you?
Yes.
Has anything been promised to you to get you to plead guilty?
No.
Has anyone threatened you in any way to get you to plead guilty?
No.
If I accept your plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea. Do you understand that?
Yes, Your Honor.
Is it your own choice to enter the plea?
Yes, Your Honor.
All right, so Mr. Robbie, you were placed on probation. One of the terms of your probation is you were to report to the probation department as often as required. Is that correct?
Yes, Your Honor.
All right, and you were asked to report or required to report on or about March 5 of this year. Is that correct?
Yes, Your Honor.
And did you fail to report that day?
Yes, Your Honor.
Why didn't you report?
I think at the time, I was already getting high. I think I can't really remember, but I think that was one of the situations.
So you relapsed?
Okay. Relapse, yeah.
Okay, and then we sent out a notice of hearing for you to appear for a probation violation, show cause hearing, and you failed to appear on April 1. Is that correct?
Yes, Your Honor.
All right, and this is actually the second time you failed to appear for a show cause hearing, just so you know that. All right, I accept the pleas. They've been given understandably, voluntarily, and accurately. She has full knowledge of her rights. She does have competent counsel. Ms. Underwood, I am going to set this for sentencing on August 20 at 8:15 if you are available, Ms. Underwood.
Yes, thank you.
All right, so Ms. Sarabia.
I don't think I'll be speaking out of school when I say, I think rehabilitation options for Ms. Sarabia should come sooner rather than later.
Well, that, I'm sure Ms. Walsh will look into that, or whoever the PO is. All right, Ms. Sarabia, we'll see you back next week, okay?
Sounds good. Thank you.
Thank you.
Is that Zoom? Is that Zoom?
Oh, Ms. Sarabia, do you want to appear via Zoom?
Yeah.
Okay, Zoom, yep, thank you.
Thank you.
Thank you, all right, so, I have a gentleman in jail, Zoom 3, what is your name, please?
Mark Ramirez, ma'am.
Oh.
Hold on. That is, Miss Beecher is your attorney, and I think she's meeting with somebody from MDOC. So I am going to change your name. And I'm going to put her initials after it. And then when she gets back, we will take you. All right. So, hold on. I see you, Mr. Barman. Hold on. Right, I have somebody just admitted on an iPhone. Could you start your audio and video? Can I ask who you are?
Antonio Simmons.
All right, Mr. Simmons, thank you. So Mr. Goldstein, I have Mr. Simmons, so give me a minute. All right. Where's Mr. Goldstein? There he is. Mr. Goldstein always finds his clients for me. All right, this is file number 2026-22605FH in the matter of the people of the state of Michigan versus Antonio Simmons. I have, I don't know, do I see a prosecutor? I'm gonna go with Isaac Sneed appearing on behalf of the people. Oh, no, Alexander
Sorry, I couldn't get my camera on.
It's okay. Alexander Bayonetto, you need to clean that camera too. Appearing on behalf of the people. So, Mr. Goldstein, how would you like to proceed with Mr. Simmons today?
Your Honor, there was a preliminary examination in this matter. We've ordered the transcript. It's not done yet. I'm going to have my secretary check when she gets in as to status, but it's not done yet.
Okay, did you order that down in district court?
Yes, we did.
I know they have like 90 days to get that done. So when would you like another date? September, October, what would you like?
The same date that you said, Mr. Vella, I think it was the 2nd of September.
Okay, so we can set this to September 2nd at 8:30 in the morning. So Mr. Simmons, September 2nd at 8:30 in the morning, write that down. And Mr. Goldstein, if you can do the stip in order to adjourn.
I will do that, Your Honor. Mr. Bayanetto, may I sign your name?
Yeah, thank you.
All right, thank you.
All right, excellent. Thank you. And Mr. Goldstein, I do not have Mr. Rosenberg. If he shows up, we can.
I'm gonna log
I'm
out.
sorry.
And see if I'm gonna log out and see if I can track him down.
Yep, and if he shows up, we'll send you a message.
I appreciate that, Your Honor. I know he knows about it because I spoke to him yesterday. So I don't know, maybe he's
Yeah, he
sleeping.
was here the last time, so I know he's been showing up, so.
All right, I'm gonna log
Mr.
out.
Simmons, you're good. You can disconnect.
Okay, thank you, Your Honor. All right, thanks, Dave.
Thank you. Okay, so let me, all right, I have somebody in the Lenawee County Jail on the first floor, and you're kind of far away, so who is that, please?
Della Garza, Bobby.
Oh, good, okay. And you are gonna have Mr. Amadeo, so hold on. Mr. Amadeo, are you, I think he was here, yep.
I'm here, Judge. Sorry, just pulled over.
Okay, this is file number 2025-22293FH in the matter of the people of the state of Michigan versus Bobby White Eagle de la Garza. I have William Amadeo appearing on behalf of Mr. de la Garza. This is date and time scheduled for a request and warrant for probation violation. Mr. de la Garza, it is alleged that you have committed some technical and non-technical probation violations. One of them, the technical violation, and we have a new probation officer, Miss Rogers, and she makes it really simple for me to read, and that makes me happy because I sometimes get lost in the files. So, Mr. de la Garza, but there are two allegations of technical violations. One is that you violated your order of probation, that you engaged in assaultive, abusive, threatening, or intimidating behavior towards an Amnesty Hodges. The second one is that you violated the terms of your probation and that on or about that same date, January 28 of 26, you engaged in assaultive, abusive, threatening, or intimidating behavior toward Nathan Dunny. The non-technical probation violation alleges that you violated a criminal law by assaulting Amnesty Hodges, and that you are currently charged with assault with intent to do great bodily harm less than murder and domestic violence second. You are currently on probation in front of me for multiple files, but on the home invasion file, the maximum penalty if you were to plead guilty or be found guilty could be up to 20 years in prison. And on the MDOP of a building, the maximum penalty on that file could be up to 5 years in prison. So Mr. Amadeo was appointed previously to you as a special public defender. And would you like him appointed on this violation of probation as well?
Yes.
Okay, so Mr. Amadeo, would you like a breakout room with them or how would you like to proceed?
Your Honor, will waive any other formal readings, stand mute, waive all statutory timeframes, be heard on bond when appropriate. I am prepared to proceed, Judge.
All right, you don't need a breakout room?
I do not, Your Honor. Thank you.
Okay, so are you asking this court to enter a plea of not guilty because of the new charges?
I am, Judge.
Okay, and Mr. De La Garza, obviously that would be because anything that was said here could be used against you in those new charges. So I'm going to enter a plea of not guilty on your behalf. And Mr. Amadeo, how far out would you like this adjourned?
We have a PCC on the 18th of August. Could we set this out maybe 3 weeks to see where the prelim lands on the district court cases?
About September 2nd at 8:30.
Thank you, Judge.
Great. So Mr. De La Garza, Ms. Adams.
I apologize. That's with Judge Olsaver, correct?
Oh, is it? Oh, evidently this is a Judge Olsaver file. So September 2nd at 8:30. Just so you know, Mr. Amadeo, it's Judge Olsaver.
Understood, Your Honor.
And just so
Okay.
the court's aware too, this would be a Hillsdale County prosecutor case. I don't know if you have that noted or not.
No, it's a Judge Olsaver file, so I wasn't aware of that, but I'm sure they'll
If you-
show up.
if
All
you-
right,
I would say if you could make sure that's noted, thank you.
that what?
I just want to make sure that's noted so no one from our office appears.
And I don't know procedurally how Hillsdale finds out about it, but I assume we send them a notice. All right, thank you. So Mr. De La Garza, you are all set.
Oh,
Mr.
Your Honor,
Amadeo, do you have anything else?
I want to be heard. Can I be heard on bond, Judge?
I'm sorry?
May I be heard on bond?
Yes.
He posted a $11,000 surety bond in district court on July 15th of this year. He's had no bond violations. He is working full-time. I am working on the preliminary examination. I did contact Hillsdale about everything going on with the PV. We were actually waiting for a PV allegation to come out for over a month. I would ask for a PR bond since he's already posted the $11,000, allow him to go back to work.
All right, and I apologize again, as this is a Judge Olsaver file, as I review the file, his initial charges were home invasion, first degree. He had a second offense notice, MDOP of a building. Both of these looks like involved another woman. And now we have new charges against, a woman and another man. So I don't have a prosecutor to address this because I've just been informed that it was conflicted out. Potentially, what was his guidelines? 7 to 20.
85.
Yeah, so his guidelines were a prison term, so I don't know what happened on the initial charge, but he didn't go to prison. So there must have been some kind of agreement, plea agreement, that he not go to prison. I'm not comfortable making a determination on bond today on this. So Mr. Amadeo, if you'd like to get a date in front of Judge Olsaver sooner than that, go ahead and motion that up. But without a prosecutor to give me input, I'm gonna leave the bond as it is. All right?
Okay, Judge. Thank you.
I'll set it at, it doesn't look like it's set, so I'm gonna set it at 25,000 cash.
Okay, Judge.
All right.
Thank you.
Thank you.
I can't get on a bracelet, a tracker.
No, your attorney will file a motion. Thank you. All right, so I got Mr. Bowerman, I have Mr. Ramirez. So, I have nobody in my waiting room. Ms. Beecher, would you like, can I take MDOC first to get him out of here?
Yes, and then if I could just speak to Ramirez before we go on the record for him.
Okay, I'm gonna have MDOC brought down. And Mr. Ramirez, I'm gonna pop you in a waiting room with Ms. Beecher while we're waiting for MDOC to get down here.
Good, thank you.
Ronnie has MDOC.
Oh, never mind. Right.
She's ready. She's just getting, looking at
Who's
this.
she got in mind? Beecher.
Let Chad look up.
Okay, me too. And Rhonda?
528. Can you bring the phone down my court, please?
Rhonda must be down talking to MDOC.
No, she's already talked to him. She said she went back and looked up his paperwork when you just pointed.
Carly Zelke, Renard Scales.
Yes, Your Honor.
Hold on, let me call it first. Hold on. File number 2026-22662FH in the matter of the people of the state of Michigan versus Renard Henry Scales. I have, I'm gonna go with Alexander Bayonetto appearing on behalf of the people and Carly Zelke appearing on behalf of the defendant. This is date time set for a pretrial. I do not have Mr. Scales. Do you have Mr. Scales?
No, Your Honor, I don't. believe, I'm not surprised that he's not appearing today. He is incarcerated in the Wayne County Jail, is my understanding. I have called many phone numbers and emailed the addresses I could find, but I have not been able to get any response there. I was able to look up his attorney for his case there, so I thought I would try that next. And he is set for exam on that case on August 27th. So that is the information I have.
Okay, well, I think what I would like to do is somehow get a holder on him. So like if something happens, so Ms. Silky, I'm going to change his bond to 25,000 cash or surety. So that way, if Wayne County releases them, we can get them back here. And then we can address bond again. So I'm gonna set a pretrial for September. Let me see here. Is this, I'm gonna do September 23rd. But if we get them sooner, obviously, I will, have them brought in. So September 23rd at 8:30, can you do this step in order to adjourn?
Yes, Your Honor.
Mr. Bianetto, can you sign your name with permission?
She can, thank you.
Okay, thank you.
Thank you, Your Honor.
Thank you, Ms. Silky. All right, Rhonda Underwood. Yes. Yeah. All right, this is file number 2025-22267FH in the matter of the people of the state of Michigan versus, is it Leroy or Leroy? Okay, I always ask because my husband's a Leroy and I never want to pronounce it wrong. So Leroy Deshawn Foster, and I have Rhonda Underwood appearing on behalf of Mr. Foster, and I have Isaac Sneed appearing on behalf of the people. This is the date and time set for a pretrial conference. Ms. Underwood, how do you wish to proceed?
Your Honor, it's taken us a while to get with a independent forensic examiner. But now I think we're going to work with Dr. Farhat, and I will be requesting an order from the court allowing him to do that examination by Zoom with the MDOC, which I believe they will desire before they allow that.
Okay.
So I would be requesting this matter be adjourned.
How far out?
Probably 60 days. Why don't we see?
Okay, so about October 14 at 8:30 in the morning.
And I would be happy to do this stip in order with Mr. Sneed's permission.
Okay, Mr. Sneed.
Yes, thank you.
All right, so Mr. Foster, we're gonna set this out to October 14 for the doctor to meet with you. And we'll be back on that day in person.
If Mr. Foster wants to be in person.
He's very soft spoken. Do you want to come in person? And where are you currently at?
Where are you housed?
I'm a WCC.
What facility did you guys come from? Okay. All right, so we'll see you back on October 14 at 8:30 in the morning. Thank you. Safe travels.
And Your Honor, I'll talk to Mr. Spence.
All right, yep, he's right back
I
there.
think the other gentleman was Ms. Features.
Yeah, okay, sorry about that. Okay, do I have any defense attorneys? All right, just bear with us, Mr. Bowerman.
No problem, Your Honor.
What's that?
Good morning, Ms. Inslow.
How are you doing?
Good, how are you?
I'm good, so it'll just be a minute. I think Ms. Beecher is talking to Mr. Ramirez, so give us just a minute.
Okay.
All right, this is file number 2023-21377FH in the matter of the people of the state of Michigan versus Michael Charles Spence. Ms. Underwood, you were appointed. Have you had a chance to speak with Mr. Spence?
Yes, I have, Your Honor. I would ask that the court continue the not guilty plea and set this out till late September, Your Honor.
Because of the pending charges?
No, Mr. Spence has some medical issues, and also we want to see if we can stabilize Mr. Spence's employment situation and get some things going, Your Honor.
All right, so Mr. Spence, obviously you have a clause that's no alcohol and that you're required to make some minimum payments. What's your minimum monthly child support payment?
$72.50. It was 84 something when I was working, but that's because I was carrying insurance on my son.
Okay, and are you currently working?
No, I'm looking for a job, ma'am. I got so many applications out. I've already had 2 interviews that they didn't take me, but I've been doing some side work because I want to try to save my apartment as well. But
You want to try to what?
save my apartment.
Okay, well, side jobs, pick up pop bottles, I don't care.
Okay.
But, you know, this obviously does carry a prison term and it's with the Attorney General's office, so we don't want to mess with that too much. So I will adjourn this to, you said the end of September. I'm going to do September 30th at 8:30. Miss Adams, could I get a notice of hearing from Mr. Spence for September 30th at 8:30 in the morning?
Okay.
All right, so Mr. Spence, you go have a seat in the gallery back there on this side, and Miss Adams will bring you a notice of hearing, okay? Make sure you're reporting to the probation department the way you're supposed to.
Absolutely, every Tuesday, ma'am.
All right, good, thank you. All right,
And Your Honor, I think that completes my docket.
Hello. Scott Goodluck? You have Scott Goodluck.
That's adjourned till September 30th, Your Honor.
All right, file number 2026-22618 FH September 30th at 8:30.
Yep.
All right, I guess you can go.
Thank you, Your Honor.
Thank you. All right, so now Ms. Beecher is still in a breakout room and she's the last one I have. When you go back there, tell her hurry up.
She's in gentle chambers. Sure.
Thank you. Beecher. Good.
Yes, Your Honor.
All right. So would it be okay if we take Mr. Bowerman?
Yes, ma'am.
All right, let me get his file. So this is file number 2. We have 4, 3, 4, 5 files. File number 2025-22242 FH, which is set for pretrial and contempt. File number 2025-22243, contempt and pretrial. 2025-22277 FH, contempt and pretrial, as well as file number 2025-22469 and 2025-22479. The matter of the people of the state of Michigan versus Gary Scott Bowerman. All of these, as I said, are contempt and pretrials. I have Christine Beecher appearing on behalf of Mr. Bowerman, and I have Phoebe McClure appearing on behalf of the people. So, Ms. Beecher, how would you like to proceed today?
Thank you, Your Honor. Your Honor, I have been in communication with Ms. McClure and Mr. Bayonetto this morning. As I know I sent the referral over for Mr. Bowerman on the 7th of July. I haven't gotten an update. I have reached out to Ms. Tusky and Rupley unsuccessfully. So at this time, I would ask for an adjournment to see if he does get accepted into drug court before we proceed.
Your Honor, Miss, can I speak up to both of you, Your Honor?
Mr. Bowerman, if you can sit forward so we can hear you better. Go ahead, Mr. Bowerman.
Yeah, I was gonna say, the jail coordinator, Miss Fitzgerald, came in and told me yesterday that I have a screening for recovery court tomorrow.
Okay.
Okay.
I didn't know if
Miss
Miss Beecher knew that or not. Yeah.
And Miss
I'm just trying
Beecher,
to-
I will, no, thank you, Mr. Bowerman. So Miss Beecher, I do know that recovery court did not meet for a certain period of time due to people being gone. So,
okay.
All right. So if he's getting screened, I can set this over. Our next recovery court is that next week, Miss Adams, or tomorrow? I don't know.
You're not here now.
I'm not here tomorrow. Next week, Miss Adams?
No, it is August 27th.
All right, so he will be screened by one of our team members this week evidently, but then we won't meet till August 27. So I can set this for September 2nd at 8:30 in the morning.
Okay.
All right.
Thank you, Your Honor.
All right, and if you can do the step in order to adjourn, we'll see you back September 2nd at 8:30 in the morning. And thank you, Mr. Bowerman, for that
All right,
information.
Thank you guys. Have a
Your
good day.
Your Honor,
Thank
could I
you.
make a brief record? He's gone.
Say it again. No, he's here. He's here.
I just wanted to make a brief record. I received a number of correspondence from Mr. Bowerman from the jail. I did share that with his attorney, so she knows what was included in that correspondence. For the record, I did read through it and considered everything that was included in that. The plea offer in this case has been outstanding since January, and that encompasses all 5 cases. As of now, I would wait for the recovery court screening, but the offer remains unchanged. But there's no plea agreement with that offer. So I think there's some wiggle room at sentencing. And I think that addresses Mr. Bowerman's concerns in his letter.
Thank you, Ms. McPhoebe.
Okay, thank you all. Thank you, Mr. Bowerman. You're all set.
All right, thank you guys. Have a good day.
All right, Mr. Ramirez, we're gonna pop over to you.
Your Honor.
This is file number 2026-225-63FH in the matter of the people of the state of Michigan versus Marcos Martin Ramirez. And Ms. Beecher, you are covering this file today for Mr. Dagger Margosian, correct?
Correct.
All right, and I have Phoebe McClure appearing on behalf of the people, and this is date and time set for pretrial. Ms. Beecher.
Your Honor, if I could just have a brief adjournment, maybe to next week till Mr. Dagger Margosian comes back. I know some of the plea agreement does have some terms in regards to Jackson County, and I haven't personally spoken to Attorney Rogers there, so I don't know what, if there's a Cobb's there, or, you know, what his case even really there is. So maybe just like a week to give Michael an opportunity to speak to them again.
Will he be back in time to be able to do all that?
He should be back next week. I mean, I can reach out to Mr. Rogers as well. It's just, I can't inform him. I can't tell Mr. Ramirez something just based off the note. You know,
right.
I didn't
So my
personally
next
speak to
available
him.
pretrial. Oh, go ahead.
Just yeah, sorry, Judge. Just to address that concern, I made my plea offer based on my discussion with the prosecutor in Jackson County. On her case as well as the case he has here, the guidelines are the same, and the offer encompasses that. The guidelines being 34 to 67. So they're the same there as they are here. So I made an offer that his sentence here would be concurrent with the sentence there. And the only benefit to Mr. Ramirez is because he was on bond when these were alleged to have been committed, they don't have to be concurrent.
Right.
For the
It's
type of
okay.
offenses that they are.
Okay,
So
because
I don't know if that helps at all, if you still want to adjourn
Yes.
it, but
well, and I
that's where
think
that came from.
would the prosecutors be inclined to not object to SAI boot camp with that sentence?
I don't typically object if they're eligible
Okay.
and the judge
Because
wants to do it, yeah.
they had a little bit lower of guidelines in the notes, so I wasn't sure. So Marcus, do you want to enter the plea today?
So it's what, 22 months? So
34, in Jackson, you're looking at 34 to 67.
what happened? What happens? Okay, so I'll be able to get boot camp though, right? If
No objection. Yep.
okay,
Well,
yeah.
Up to
okay,
MDOC.
now let's talk about that. Hold on a second. I can't ever guarantee you'll get boot camp because they have to screen you, right?
Right.
So when you go to intake, they screen you if you're eligible. They send a letter and they ask us if we object. I typically don't object because I think it's a good thing. But you know, I can't 100% guarantee that they're gonna find you eligible, but I don't know that you wouldn't be.
Yes, it's my first time going to prison, so I'm new to all this, and you know, I try to, you know, I try to.
And I don't want to rush you into this. If you want to wait a week and talk, you know, think about it and talk to Mr. Decker Margosian again and Ms. Beecher again, that's fine. I don't want to rush you into a plea.
Yeah, because I've been here for 8 months, you know, I've been here for 8 months, and you know, I miss home, so I just kind of want to really get all this over with. But at the same time, though, you know, I don't want to be away from my daughter. She's waiting for me too, so I got a lot going on out in the world, and you know, if I'll take the plea. Like I asked her if they can help me out. Like I run her with the GPS scanner. I never had a chance to be out and be there for my family and get everything situated before sentencing.
Okay, Mr. Ramirez, my question was we all got a lot going on in the world. So, and at the end of the day, you get in trouble, takes you away from your family, right? So, you know, what I'm saying to you is we just threw a lot at you. If you want to adjourn this a week so you can have time to go through it slowly and understand fully what the consequences are, I have no problem adjourning this for a week.
Yes, we'll adjourn it for a week then.
Okay, so I'm gonna set this out to, whatever this week is, August 19 at 8:30 in the morning. And that'll give you time to, you know all your options and so forth. And then, Ms. Beecher, can you do the step in order to adjourn?
Yes, Your Honor. And do I have permission to sign it, Phoebe, with your name?
Yes.
And Your Honor, could I address bond for Mr. Ramirez?
Sure.
Your Honor, I would just ask that currently he has like a $2,500 cash surety bond in Jackson. I would ask for a PR bond here with the stipulation of a GPS monitoring device. So to make sure that he's not in contact with either of the victims and give him an opportunity to get back to work. He is a journeyman. He works for the union. And I think if he's going to go to prison potentially for an extended period of time, that it would benefit him to make some money for his family in the interim.
Thank you.
Okay, Ms. McClure, and I will make note of the court that he has violated bond conditions previously by contacting the victim. So, Ms. McClure.
Yeah, that's what I was going to say, Your Honor, is this bond has been addressed a number of times. Neither Jackson County nor our courts have agreed to reduce bond any further, given that the way the offenses were committed, with being on bond for one when the other was committed, and they are serious felony offenses. Excuse me. There have been we actually had to add a charge of witness intimidation because of contact specifically about the case and the facts as they've been alleged. I think bond is appropriate as set, and I think if the court does lower bond, he's still going to have the holder out of Jackson County. He's just going to go there.
Yeah.
And you're getting, Mr. Ramirez, you're getting credit for time served, which means that you'd probably get sent to boot camp sooner or not. But Ms. Beecher, anything else?
No, Your Honor. Thank you.
All right. The allegations here are serious, and there are charges in Jackson County that were committed while he was on bond here. And there has been violation of bond conditions before, so I'm not comfortable releasing you on a care bond. So we'll see you back next week with Mr. Dagger Margosian. Thank you.
Thanks, Your Honor.
Okay, so. Okay, so, Miss Beecher, I do have in the courtroom your client. You want to scoot
Okay.
down here?
Yes, ma'am.
Thank you.
Thank you.
Oops.
Judge, I think that's all I had with you for today. Thank you.
Thank you.
Judge, what was Mr. Goldstein gonna do with Rosenberg?
Well, he was gonna try to reach out to him. Mr. Rosenberg appeared last week, so I was surprised he wasn't here.
And he
David
reported
Goldstein was-
too.
I know, so I think this is just confusion. He hasn't showed up yet. If he doesn't, I'll probably just adjourn it because he is doing what he was supposed to do, so.
He reported this week and we talked about it. So yeah, I don't know. All right, then I'm just gonna sign off.
I don't have his phone number to call him, so. Yeah.
All right, I'll sign off.
David Goldstein. All right, thank you.
Thank you.
Mr. Boyd walked into court facing a Class A misdemeanor charge of deadly conduct, but this hearing ended with a sentence that gave him a major opportunity to avoid a permanent conviction. The court confirmed that the state had elected to proceed on the lesser included misdemeanor charge, and Mr. Boyd entered a guilty plea. The judge carefully asked whether he was pleading guilty freely and voluntarily, and whether he was pleading guilty because he actually committed the offense. After confirming that he understood the documents he had signed and the consequences of the agreement, the judge explained that the deal called for 1 year of deferred probation and a $500 fine. The judge then explained the biggest benefit of the agreement. If Mr. Boyd successfully completed probation and followed every condition, he would avoid a conviction on his record and the case would ultimately be dismissed. But there was also a serious warning. If he violated the conditions of probation, he could be brought back into court, found guilty, and face up to 1 year in county jail. So although the guilty plea sounded like the end of the case, it was actually the beginning of a 1-year test. Mr. Boyd now had an opportunity to prove that he could follow the court's rules and walk away without a conviction. The judge also made sure he understood that the agreement included a waiver of his right to appeal. After accepting the plea, the judge directed him to meet with probation so he could receive all of the paperwork and understand exactly what was expected of him. The message from the court was clear. The judge was giving him a second chance, but that second chance came with conditions, and breaking those conditions could completely change the outcome. But the courtroom took a much more serious turn in the next major case. Harold Denton was facing a motion to revoke his community supervision after originally receiving a 10-year prison sentence that had been probated for 10 years for assault on a peace officer, a second-degree felony. The motion alleged multiple probation violations, including repeatedly failing to report to the probation office, failing to provide updated contact information, failing to enter a mental health caseload, failing to complete a battering intervention program, and failing to successfully complete required outpatient aftercare. When the judge went through the allegations one by one, Denton admitted that several of them were